Welcome to this video on short time and layoff in Ireland. I'm Tommy Miles of Employment Rights Advice, a specialist employment law consultancy based in Monaghan and serving all of Ireland. This is an employer's guide to short time and layoff. We will look at layoff and short time definitions, the question of payment, redundancy, annual holidays, and further info. Layoff and short-term defined. These are set out in the Redundancy Payments Acts 1967 to 2014. Short time is where an employee's hours of work or pay are reduced to less than 50% of normal weekly hours or pay. Layoff is where an employer is temporarily unable to provide sufficient work for the employee. You must have a reasonable belief that the situation is temporary. You would normally have to give notice, but in the current COVID-19 crisis, short notice could be justified. You must not discriminate when choosing the employees to lay off or put on short time. Must I pay workers on short time or lay off? To answer this, you need to examine each worker's contract of employment. There must be a clause in the contract allowing you to place a worker on short time or layoff without their consent. It may be the custom and practice in your particular industry to do so, in which case you could argue that you have an implied right to do so. What about redundancy payment? An employee can notify the employer in writing of their intention to claim statutory redundancy payment, provided they meet the criteria. This right arises where the employee has been laid off or put on short time for 4 or more consecutive weeks. Where the periods have not been consecutive, the period is 6 or more weeks within a 13-week period, of which not more than 3 are consecutive. The notice must be given by the employee to the employer before 4 weeks of the ending of the layoff or short time period. You as an employer can give a counter notice to the employee denying the redundancy payment on the grounds that you can offer them at least 13 weeks' work without being laid off or put on short time. Consider the use of annual holidays. As an employer, you can decide when an employee takes their annual holidays. You must take into account the employee's family responsibilities and opportunity for rest and recreation. You must consult with the employee or their trade union at least 1 month before the leave is taken. This is just a short summary of what is available to you as an employer in terms of layoff and short-time working. If you require assistance, please contact us using the link in the description below.